Namaskar ma'am, namaskar sir.
Please sit down.
Thank you sir.
Will you introduce yourself?
Sir, my name is Chaht Chhabra. I have done my schooling from Sanskriti KMV School and I have done my BLLB from Guru Nanak Dev University Regional Campus Jalandhar as a gold medalist, and after that I am preparing for judicial services because it's my childhood dream to become a judge.
Hobbies?
So in my leisure time, I like dancing of different forms, like sometimes I like to do Rajasthani folk, sometimes semi-classical, sometimes I even dance on patriotic or even wedding songs, and sometimes I dance on soft Christian bhajans. And I have, apart from this, I have fixed 2 days in my week, Saturday and Sunday, since I love teaching. So there are some juniors at my college and I love to teach them law subjects.
In your childhood or during college days or in the university, did you happen to become member of some group who used to settle the disputes between the
Yes sir.
warring functions?
Yes sir, fortunately I was the head girl of my school and therefore I have ample of such opportunities where I had to manage such situations.
Why it is head girl, not head? Gender neutral नहीं है.
So there is a head girl.
If it is a head boy, then it is a head boy. If it is a girl, it is a head girl. Is it? Or it was purely girl institution?
No sir, it was a co-ed institution. Along with the head boy, there was a head girl. Both of the posts were there.
So who was boss of two?
So of course our teachers, our respected principal ma'am.
No, you were equal.
Yes sir, we were on equal.
Okay.
Yes.
Same class?
Yes sir, we are in the same class and also we are best friends.
Why you want to become a judge?
So it actually developed gradually. So when I was a child, so normally every teacher who comes to the class asks one single question from every student as to what do they want to become in life. So every student used to say, I want to become doctor, engineer, teacher. So I wanted to do something different. So there was one cousin of mine from Hoshiarpur. Presently he's in America. So he was at that time preparing for judicial services. From him I got to know that there is a field called law and there is a post called a judge. So for the namesake only, I started saying I want to become a judge.
You cherished it in your childhood?
Yes sir, I cherished it.
Keep your dream till you actually got the chance to prepare.
Yes sir, actually I want to say one more thing, that credit of me choosing law as a field goes to one book. So that was a black color book of M. Lakshmikant. So I used to go to a library. So every time I used to go to library, I used to read this book. And this book was on constitutional law. And finally I decided that why I'm saying only for the namesake I want to become a judge. If I'm loving law, then why not pursue it as a dream? Why not make it a goal? And finally I decided that law is what I have to do. So credit goes to that constitutional book.
Who was head of the Constituent Assembly?
So the head of the Constituent Assembly, initially it was Dr. Sachidan Sinha. He was elected as a temporary president, and thereafter finally Dr. B.R. Ambedkar, he was president of chairman of drafting committee of the Constituent Assembly, and M.N. Roy, he was a constitutional advisor.
How come we are amending our constitution frequently?
Sir, because constitution is a dynamic document. It has to change as per the changing times, as per the changing needs and aspirations of the society. And as a result, we have to make amendments time and again.
Does our constitution provide some future guidelines how we should proceed in future?
Yes, sir, of course. Along with the fundamental rights, we always say that we have been given a lot of fundamental rights, but along with that, it also has a set of fundamental duties. It guides us as to, at the same time, we have the rights, but at the same time, we must also be conscious about our fundamental
duties. Are these duties enforceable?
No, sir, they are non-justiciable in nature. That means they are not enforceable in the court of law.
Then what is the use of keeping it there?
So they aim to inspire us, they aim to guide us, that along with the rights we have to be conscious about our fundamental duties. No doubt they are not enforceable in the court of law, but they are a part of the grand norm of a country, the constitution of a country, and we just cannot afford to ignore them.
Can the fundamental rights be suspended?
So fundamental rights, there are 6 fundamental freedoms guaranteed under Article 19 of the Indian Constitution. So whenever national emergency is being declared, so automatically they...
Who can declare it?
So they automatically
Can
get...
CM declare it?
So emergency?
Yes.
So national emergency is declared by President on the advice of Prime Minister, who is further advised by the Council of Ministers.
Whether these automatically get suspended?
Yes, as per Article 389 of the Constitution, if I am not wrong. I think, no, this is not Article 389. So this is Article 359.
Leave the article, what the substance is.
So yes, I'll tell you the substance. So the fundamental freedoms guaranteed under Article 19, they get automatically suspended. Whereas if we talk about the other fundamental rights, for their suspension we need a special president order, and they do not get automatically suspended. And moreover, only their enforcement is being suspended and not the rights itself. Exception is carved out in case of Article 20
Is the right
and 21.
to go to courts get suspended?
No, sir, it doesn't get suspended.
You said automatically suspended.
Sir, I'm telling that as far as other fundamental rights are concerned, they get their execution gets suspended, but that for that president's order is required. But there are 2 exceptions, that is Article 20 and Article 21 of the Indian Constitution, because they are the inalienable, they are transcendental and the most sacrosanct rights, and therefore they do not get suspended even during emergency.
Do these rights are given by the Constitution?
So yes, they are given by the Constitution.
Right to live?
Right to life. So yes, Article 21 of the Indian Constitution.
Can the life of a person be taken?
So life of a person, so as per the ruling given in the Gyankor versus State of Punjab, Article 21 that has been incorporated in the Constitution for the protection of right, and it cannot be interpreted in such a manner so as to, it cannot be interpreted in such a manner that we take it as a right which could terminate the life. So it cannot take away the life. Of course, we have exception of passive euthanasia. In those extreme circumstances, on the will of the patient or the spouse or any other relative, it can
is done by himself. He himself desires to die. We say the other person.
So,
can the government take life of a person?
No, sir, government cannot take. But sir, yes, I want to add something over here.
Courts give the punishment of hanging a person.
Yes, sir.
They take away the life of a person.
Yes, sir.
Against the fundamental right.
Sir, but that is, so it is well said that in trust of the public, that is the supreme law. We have even a maxim in this regard, salus populist. I'm not able to recall the proper maxim, but it says that public interest, that is the supreme law, and if there is a person who is disturbing the public peace, the public tranquility, and his presence...
Public peace? It is a very minor offence.
So, for minor offence, of
he
course...
can only be detained for that. He can't be killed
yes,
for
sir,
that.
it's only in exceptional circumstances where a person is a continuing threat or menace to the society. He has committed such a crime that has shocked the conscience of the entire society. Only then the court has a right to take away that person's life.
He's a corrupt man. Does he have a right to live?
Sir, corruption is, if it is of great magnitude, then of course a strict sanction can be imposed against him.
He can be punished.
So
with
yes, he
death
can
sentence.
be punished. So I'm not well versed with the provision concerning that, but as far as Prevention of Corruption Act is concerned, I think that I'm not sure with the punishment part, but he can be imposed, a strict sanction can be imposed against him, and I think corruption is an offence that can call for death penalty if an amendment is being made.
A person commits a murder.
Yes, sir.
He not commits a murder, there is a charge of murder against a person.
Alright, sir.
Trial is held, he is convicted, sentenced. After he serves the life imprisonment, it transpires the man was alive for the murder of which he was sent to jail.
Sorry, sir, I'm not able to understand the question. Can you please repeat?
ਇੱਕ ਬੰਦਾ ਸੀਗਾ ਉਹਦੇ ਤੇ ਟ੍ਰਾਇਲ ਹੋਈ ਵੀ he killed A. Trial was held, witnesses were recorded. Judgment was that he is guilty of murdering A and was sentenced to life imprisonment.
Alright.
Then after he served the life imprisonment, it transpires that A is still alive.
A is alive.
Yes. Can he kill A? I have already served the sentence for murdering him. Let him murder me. Let me murder him. Allow me to murder him since I have served the sentence for killing
sir,
A.
I got it. Yes.
Now what is your answer?
So, of course, that there is a fault on the part of the prosecution investigating agencies.
That fault goes away. He has already served the sentence. If he kills A, maximum sentence which can be imposed, he has already served.
Yes, sir,
Can
I
we
understand.
grant him the right to kill A since he has already served the sentence?
No, sir, he cannot be given the right.
Why?
Sir, because there was a fault on the part of, all the authorities that they did not do the investigation properly.
Can we give him 12 years back or 14 years for which he
Of
remained
course.
in incarceration?
No, sir, that cannot be given. Of course, a huge infringement of his right is being made. That is completely unjustifiable. But that doesn't mean that he'll be given the right to kill that person again. Of course,
If he kills A, supposing he doesn't ask for permission, he says, I am justified in killing it, then trial again takes place. He says, I have already served the sentence.
no, sir, then
Then
he will not be tried.
दोबारा
again.
कैद होएगी उन्हों के नहीं होएगी?
नहीं, sir.
नहीं दोबारा मर्डर करता ना उसने फिर.
Sir, but he has already served the sentence. It will be set off again under section 428 of
Wrong.
CRP.
It can't be set off. पहला तो offence हो ही नहीं सी.
Yes.
He can only be compensated
Yes.
for the wrong done by the state. The persons, the investigating officer, the witnesses, they can be sentenced and he can be compensated with money.
Yes.
Of course, we cannot give
We
him
cannot
his
try
14 years incarceration and the blame for which he was.
Yes.
Social stigma भी तो है ना एक बंदे दे जो murder का charge
yes,
लग गया.
sir, definitely.
But he will again have to serve the sentence for the offence which he committed. Double jeopardy सुना तुसी?
Yes, sir.
की हुंदा?
So, if a person is already being tried by court of competent jurisdiction and thereafter he's either acquitted or he's convicted.
If he is discharged,
So, if a person is discharged, a discharge is not equivalent to acquittal. He can be tried again. In fact, under explanation appended to section
where it is
300
barred?
Yes, sir.
CRPC?
Yes, sir.
Is
Sir,
there any other provision?
So yes, there is Article 22 of the Indian Constitution.
Can one person criminal be compelled to give evidence against himself?
So he cannot be compelled. It depends upon his personal will. If he wants, he has to make an application writing as per the mandate of section 315 of CRPC. He cannot be compelled to
You
give an
ask a
evidence.
man to give his sample for DNA examination in certain cases. Can he say it is my right to give or not to give?
No, sir. In that case, he can be compelled because giving a specimen of handwriting, signature, or blood sample for the purpose of investigation, that cannot be said that he is compelled to be a witness. State of Bombay versus Karthik Halu, it has been
If you
held.
ask him to give his specimens in fraud cases, does he have कुट के ला सकते उसका signature देने पैणगे?
So, sir, as per section 53 of CRPC, he can be asked to give the sample and even
Sample नहीं, signatures.
yes, sir, signature also.
Court directs him to do it. He says I won't do it. Then
So, that is for the purpose of investigation.
yes,
And he can be asked to give, and
court has asked him. He says I won't do it. Then
then adverse presumption will be drawn.
okay, sir. ज़्यादा हो गया.
Chahat, 2-3 things. What you replied, I'm going to take it up from there only. You first said that Sachidanand Sinha was the speaker. He was the president of the
Temporary
Constituent
president.
Assembly. Then what was Rajendra Prasad? There were two speakers.
So, yes, sir. Initially, when on the first meeting of the Constituent Assembly, Sachidanand Sinha was elected as a temporary president, and thereafter Rajendra Prasad, he was elected as a permanent president.
Was only one or two?
Sir, there were two. One was the president, and the other was a vice president. And
Vice
H.C.
president.
Mukherjee.
There was no vice president post. The constitution
So,
was not come.
So of the constitution, of the
It is
constituent,
before
was-
the
who was-
constituents. Constituents ਤਾਂ ਹੈ ਹੀ ਨਹੀਂ ਸੀ ਜਦੋਂ ਦੀ ਗੱਲ ਕਰ ਰਹੇ
so of
ਹਾਂ
the constituent assembly.
ਹਾਂ ਯੈਸ ਦੋ ਸੀਗੇ
Sir, yes, one was H.C. Mukherjee.
ਓਕੇ
Malvankar, who was Malvankar?
So the Constituent Assembly, as per the Indian Independence Act of 1947, the Constituent Assembly used to sit as a legislative body, and it also used to sit as a Constituent Assembly. So when it used to sit as a
India Independence Act.
so yes, Indian Independence Act of 1947.
Okay.
So whenever the Constituent Assembly, it said that one was a mandate of that act. It said that Constituent Assembly that is going to make the Constitution, but also it will be.
Was it not a decision of the Constituent Assembly itself that one will be the Constituent Assembly, which will only frame the Constitution, and one will take up the normal laws, the
Yes,
normal.
so whenever it used to sit as a legislative body, then it was headed by G.V. Mavlankar.
Yes, and otherwise it was.
Otherwise, it was Rajendra Prasad.
Secondly, you use the word national emergency.
Yes, sir.
Is the word national emergency used anywhere in the Constitution?
So the word national emergency, I think it is not. maybe.
Article 352 uses the word proclamation of emergency.
Yes, sir. It doesn't
Okay.
exactly uses that
Okay,
word.
okay.
internal emergency Is it-
Proclamation.
Proclamation.
Yes. Okay. Now, you have also talked about the suspension of fundamental rights.
Yes.
Which amendment brought about the suspension of fundamental rights will not be there? It said no suspension.
So 44th Constitution Amendment Act.
Okay. Now, you were talking about that when a person wants to give what we call a living will, that is what sir was hinting at.
Yes, sir.
So that he was actually talking about living will.
Yes.
What is the law of living will, and which judgment was it?
So Common Cause versus Union of India. If a person is suffering from a terminally ill condition, then he can give the consent.
Who will take a decision?
So as per the judgment, first of all, the application has to be made by the spouse or any relative of the person, even by the doctor. Thereafter, High Court.
Not he himself.
So if that person, he's lying on a bed, he can express his will, then his doctor or the relative will take it forward to the High Court. Then High Court special two-judge bench
That
will
means
be
we are
constituted.
allowing euthanasia.
Passive euthanasia.
We are allowing in India.
We have recognized after Aruna Shanbo case.
Have we?
Yes, sir.
Is it with some riders? Or tomorrow we can ask all the doctors कि passive euthanasia तो करो आराम से.
No, sir. There is a proper set of guidelines. It's
क्या
only,
guideline है?
Sir, first of all, the application will be made to the High Court, and number second, the High Court special judge bench will be sitting over there to consider the application, and further three doctors panel will be constituted, and that too by the state government along with the recommendation of Chief Justice of the High Court, and they are going to assess the.
So this is the procedure whenever any passive euthanasia is to be
Yes,
effective.
sir.
It can't be at the whims and fancies
No,
of a
sir.
doctor.
No,
Okay.
Sir, एक illustration है.
हाँ जी sir.
Dr. D.N. Jauhar, you heard about him?
Yes sir.
I don't think whether he filed a writ or not, but there was a newspaper cutting that he appeared in the court and made a statement. In case at any stage of my life, husband and wife both got their statement recorded before the judicial magistrate, might be at the direction of the Honorable High Court only, that if at any stage of my life I go into certain terminally ill disease, there being no likelihood of my getting alive, then passive, the will was allowed in such cases. I don't
my
think.
professor in English literature.
Achha ji.
Okay. Now, sir was talking about death penalty, and you were talking that it according to public interest and all that.
Yes.
What is Article 21? Is it your life and liberty? Is it subject to something?
right to life and personal liberty. So
My Article 21 is right to life and liberty,
yes,
subject to.
so subject to reasonable restrictions on
Sorry?
the exercise of that right. So
Su-
every
subject to?
right, like we know that every right is not absolute, so it can be subject to certain.
No.
Can be taken away by the procedures established by law.
Yes, according to procedure established
That
by
was the
law.
answer he was searching.
Yes, sir.
And
This
also-
answer you should.
And
Procedure
also,
established by
also,
law, I missed to
also
say
section 78 IPC. Hangman is allowed. He's protected.
Yes, sir. Yes.
Okay, so this was your past. I was just brushing up. Now let me
Yes,
take up
sir.
my questions.
ਮੈਂ ਜਿਹੜਾ ਛੱਡਤਾ ਸੀਗਾ ਉਹ ਇਹਨਾਂ ਨੇ ਫਿਲ ਕਰਤਾ.
No, she must know because when she's going,
Oh,
she
yes,
must know.
Yes,
So
sir.
we-
I forgot.
Okay.
Could not
We are not only taking interview, we are preparing you for that.
Yes.
Yes, sir.
Okay. When was the first Law Commission of India established?
So first Law Commission of India was established under the Charter Act of 1833, and the Law Commission was established in the year 1834.
Who headed it?
Sir Lord Macaulay.
Okay. Now, the Law Commission, is it a constitutional body or is it a statutory body?
So Law Commission, it is not a constitutional body.
Okay.
It was a body that was a statutory body.
Any statute?
No, sir.
So please remember, it is merely a executive body. It is neither a statutory body.
Alright.
Okay. अभी कौन सा Law Commission चल रहा है?
So, sorry, sir, I do not.
22nd Law Commission. It's
22nd.
अभी तो न्यूज़ में था. Its term has been extended. Okay.
Sir,
Whatever they propose particular laws, is it binding on the parliament to make law? Whatever is suggested by these
Parliament should consider it, but the
should.
So it is upon the discretionary will of the Parliament.
You said should.
So it is just advisory in nature.
Yes.
And the,
We want advisory answer from you.
Yes. Okay. When was the Constitution of India enacted and adopted?
so it was full-fledged complete by 26th November. And then it came into force finally on 26th January. The
We
day
call
of
it came into force or commencement?
So it came into force.
Article 394, what does it say? It shall be called commencement of the Constitution.
Commencement.
Okay. Now, did any article come into force on 26th November 1949?
So I think the initial sections which are dealing with the formation of state.
Sections? Which
Oh,
section?
articles, sorry. sir.
Initial. Article 1, Article 2, Article 3, Article 4.
I guess concerning the formation of state, I think the basic articles of the
Article 394 tells us that 394 and 15 other articles came into force on 26 November 1949.
Alright.
Okay, fine, no problems. We'll get out of Constitution for some time.
Yes.
Let's go into CRPC. What is an inquiry?
So inquiry is a proceeding as per the definition clause that has been added and that is incorporated in under the section 2. So inquiry is a proceeding that is conducted before a judge or magistrate, but it is not a trial. So basically the purpose of inquiry is to find out as to whether there is a sufficient
Decision
ground
on
of
a
proceeding.
bail, is it an inquiry?
So decision on a bail, that is if we talk about the bail, that is also of different types. First of all, it is a
No, I'm not bothered about the types of bail. I just want to know whether
When the
bail.
inquiry starts,
So inquiry starts when the magistrate for the first time applies its judicial mind and it is satisfied that in order to find out whether there
on
is
what basis?
so on the basis of a police report and the documents accompanying
Only
the
police report.
So along with the police report, there are documents also sent along with it.
Police report means report under section 173 accompanied by the statement of the witnesses and the documents.
Yes, sir.
It is a complete document called police report.
Yes, sir.
So
Is
now-
the inquiry starts after the
Yes.
police report only?
So
Or
first
there
of all,
is
the
any other-
magistrate has to take a cognizance.
Cognizance is a different thing. We are saying what is inquiry, who conducts the inquiry,
So magistrate.
when it initiates,
So when the police report is being made, that is
Suppose we want to take up a matter, bail matter, before the police, suppose 173 की अभी report नहीं आई, judge has to decide whether to give bail or not.
alright, sir.
Is that an inquiry?
So that is not an inquiry.
Then what is it?
So inquiry means when the magistrate applies its mind for the purpose of deciding
Please go
further.
through the judgments. Anything before the trial is all comes under inquiry. So when you are deciding a bail, it's an inquiry.
You have taught this, sir.
Are you my student?
Yes, I'm your online batch student.
Achha, okay. Fine. Achha, it's better that we don't have, it's better to prevent an offense.
Yes, sir.
So, how do you prevent offense in CRPC?
So there are a lot of provisions which are preventive in nature. First of all, the police if we talk about the preventive powers which a police officer has, if a police officer finds that like under
Let's
section,
talk about a section which preventive
so
power
section,
police has.
So section 151.
Okay. And what about the executive magistrate?
So executive magistrate, it can also, if it finds that there are a lot of provisions concerning that preventive. For example, if it's concerning the dispersal of unlawful assembly, and then security for keeping peace and good behavior.
108, 108, 109,
Yes, sir. Security preventive action of the magistrate. Magistrate finds that the person he's a habitual offender, or if he's.
Can he so much to take cognizance?
Sir, it is written over there, like if we talk about section 107, it says that if the executive magistrate is satisfied on the report of a police officer or any other source.
I said so, other source has it. अच्छा
Okay.
देखते
Yes,
नहीं ना अपन जुडिशल ਨਾਲ नहीं ना डील करते.
Okay. What is the rule making committee in CPC? What constitutes the rule making committee?
So rule making committee, I think that is dealt under section 123 of CPC.
Okay. Who all are there?
So I can make a guess. Actually, I do not remember that.
Yes, go ahead.
Okay, go ahead.
So that comprises of a district judge, and thereafter 3 other
District
judges.
judge.
District judge
कहीं
is a
लिखा है?
simply member. Only the High Court constitutes it.
High Court constitutes it, and district judge is a member.
He can take district
How
judge as a
many
member.
are there High Court judges also involved in the rule making committee?
Yes, sir, High Court judge
How
is
many?
also there. I'm not able to remember.
Can advocates be made member of the same?
Sir, I don't think.
Yes, 2.
Yes, they are members.
So I need to brush up.
Yes, you
You
need
read
to brush
read
up.
these things. है ना?
Okay, ma'am. Please.
Topic change कर देना.
It's too much.
We
But
got
this is how you will be
into
grilled.
more
So be
depth.
prepared for
Yeah.
this. Please.
Because you were fully prepared, we went grilled you further.
And moment I learned that you are my student, the grilling was more. Chalo, please. Aap.
Please.
So, what is the nature of proceedings under Domestic Violence Act?
Under Domestic Violence Act. So, ma'am, it is quasi-judicial in nature.
Because like my question to you is exactly like whether it is criminal or civil in nature.
Ma'am, I think that is Domestic Violence Act. It basically deals with the orders which magistrate can pass, like residence order, protection order, custody
Right.
order.
Right.
So I think they are not criminal in nature.
Okay.
So I think that is more of a civil one.
But you name magistrate.
Magistrate. Yes, ma'am.
Are
So-
the offences punishable under Domestic Violence Act?
So as I just had a look on it and I could only recall the orders.
If she says she was given beatings, harassed
The
by the
magistrate-
husband for dowry,
Yes, sir.
then if it is covered under domestic, is it punishable?
So I came across a section where it was written. I just had a chance to look at the beginning sections only. There was a section where it was written that magistrate or protection officer may ask the women to lodge a complaint under section 498 of.
Can complaint be made to a judge?
Magistrate.
Then it is criminal proceedings.
Yes.
So, do you think the Domestic Violence Act should be made a general neutral law?
Yes, ma'am, I think that is a
And
need.
why do you think so?
Because, ma'am, we are living in a country where gender equality that forms the very basis of our Indian Constitution. It is one of the ideal enshrined in the Indian Constitution, and I think it should be definitely made gender neutral. Because even if we look upon Section 498A, we can take an example of it. There have been many wives who are using it as a sword rather than as a shield. So they are there are many such disgruntled wives who are trying to harass the husband. So why? Because we are more favorably inclined towards women. That's why they got an opportunity to use it as a sword. So,
But Constitution is favoring women.
yes,
There are
sir.
special provisions for the
Special
women,
provision, of course,
enabling provisions for the state to give special rights, special laws for the women.
Yes, sir, that is definitely correct. But we can also not forget that a major chunk of our population is male population only, and they are also the victims of cruelty as much as the women are. So, as we know that we have a dynamic law, it keeps on changing with the changing needs of the society. So, considering that in view, I think law should be amended and should be made gender neutral in consonance with the Indian Constitution.
Alright, so the definition of the aggrieved person as per you has to be changed,
Yes.
including males as well.
Yes, ma'am, it's my recommendation and it should be done.
Okay. So suppose you are a rent controller and a landlord has filed a petition against the tenant for eviction. But tenant denies that, he's actually a tenant. So basically, he is denying the title of the landlord, and he is actually denying that he is the tenant who's being given the possession by the landlord itself. So basically he is denying the relationship between two. So are you competent enough to adjudicate the relationship of the two parties?
Ma'am, in that case, since the relationship is being involved, I have gone through a case. I do not remember the case exactly, but there it was written that if such an allegation is made concerning the relationship, in that case, even if the rent controller decides, civil court is still competent to deal with that portion again. It will be better if it asks the civil court directly to take that matter.
Okay.
Chahat, 2-3 comments. Firstly, you speak too much. Control, hold your horses. Don't be in a hurry. And wherever you are not very sure, do not be forceful about that. At 5-6 places, especially with sir, I was noticing that many places you were wrong. But you were very forceful. You were trying to ram it down as that, okay, no, this is what you have to guard against. Because, they will not take very kindly to this. Have your facts clear. If they are not clear, just say, sir, I'm very sorry, I'm not very sure about it. Always give a writer, so that we know that you are honest and you are being about it. Secondly, I think you need a revision of all your laws. And the positive points are you're confident, very pleasant, and definitely endearing. We definitely like that. And you have knowledge of law. But only thing is, it is little misplaced. I mean, thoda uska idhar aa gaya, iska idhar aa gaya. You have to settle your mind and do quickly.
Just give a little pause before you formulate your answer. That pause will organize your matter, which are to be given priority, about which you are 100% sure. You must reply enthusiastically, emphatically, right?
Yes, sir.
The things which you have just vague idea, you may seek permission to take a guess, make a guess, right?
Definitely.
Yes, Chahat, I think you need to be more humble, and I think you were a little bit aggressive, which even I have noticed. You were being pushy and first any of the interviewer first finish the question and then you may start.
Yes, ma'am,
So as sir is
definitely,
saying,
I
just
agree.
give a pause, because it was nothing and moreover, when someone asks you a question, just try to look at that person at that very moment. Don't look here and there. So overall, you did well.
Only thing is, be as
Advocate
ma'am
may
rightly
be
said.
little aggressive,
Yes.
but judge has to be without aggression.
Yes, sir. Bilkul. So
Is
I
it?
did not realize that, and I'm really sorry if I.
No, you
So
are
I will definitely
a
improve.
judge in your own right. Judge inside also. From outside you are real judge. Inside also grow like a judge.
You will
ठीक है?
definitely make it.
हाँ.
Just see, you are abhi, what we call raw. We can see the rawness in you.
Yes.
But just try to mature up on that. So don't be in a hurry. You will become a judge. Don't you worry. But just polish up your law. You have scored 95 out of 150. Okay.
Alright.
You can definitely no aggression and just be. But otherwise, your positives are very good positives, and definitely you should make it.
Knowledge wise you are very good. Your knowledge is already tested in the written exam. Now it is a personality test. Take the interview persons in your area of strength, lead them into that so that they ask more on that side, isn't it?
Yes.
Add certain things from your own side if you have some extra knowledge about certain matters which can be introduced in the reply, isn't it?